Hi, this is Kowski for AP Gov Review, and in this video segment, we're going to be looking at all the Supreme Court cases that you're required to know. The AP Gov people at the College Board have condensed the number of Supreme Court cases that you are required to know quite considerably starting in 2018-2019. So if you're reviewing for this exam in the 2018-2019 school year or after that, this video certainly will pertain to you. And we're going to look at part one of some of these cases so that it's no longer a shot in the dark as to which cases you need to know. They have provided a specific list along with some of the important facts that you're going to need to know about them. So the first one, known as MCCULLOCH v. Maryland, happens in 1819. And this is when Maryland is trying to tax the Bank of the United States. A state is trying to tax the national government. And ultimately, this is where the elastic clause is going to come in, which says that the government can do anything that's necessary and proper. And it was necessary and proper, according to the Supreme Court, to have the Bank of the United States, at this point, situated in Maryland. And why this is important is that it's going to establish the supremacy of the U.S. Constitution and federal laws over state laws. So this is a big case that's going to bolster the power of the national government over the states. And this is going to not only use the elastic clause, but it's again going to be, in some ways, strengthening the federal government through the supremacy clause. And again, notice how this is going to change the relationship between the national government and the state government, in that more power is given to the national government. Another case that happens in 1995, this one dealing with the Commerce Clause. And the Commerce Clause has also been a major clause that has allowed the national government to expand its power over the states quite considerably. It allows for lots of regulation. If you fly in the air, the FAA. If you watch television, it's regulated by the FCC and so forth. You have also the FTC, SEC, so many different bureaucratic agencies that regulate a lot of different types of commerce. Well, in this case, Congress passes a law that says it's illegal to possess a gun in a school zone, and they make that a federal crime. And you have some states that are going to challenge this in saying that, well, what does this have to do with the Commerce Clause? And the Supreme Court agrees that this is an overstep by Congress as they attempt to regulate, in this case, guns, and it goes well beyond the bounds of the Commerce Clause. So this scales back the amount of power and the reach of the Commerce Clause, as well as to what extent can things be regulated by the national government. So this sort of puts the federal government in its place, as it's been expanding power for quite some time over the states, and now this is a little bit of pushback from the states. Again, notice how this is going to change the relationship between the states and the federal government. All right, going to the First Amendment here with 1962, public schools cannot sponsor religious activities such as holding school prayer in ENGEL v. VITALE. And this means that you cannot recite any prayer over the loudspeaker. You cannot hold prayers, as a teacher. And again, remember, this is going to pertain to public schools. This is a violation of the Establishment Clause right in the First Amendment. Now, again, this is something that the College Board is going to be emphasizing on some of these cases here. Notice that the Bill of Rights are being balanced between the power of the government and the civil liberties of the citizens. Now, what will be ruled in this case is that if a student wants to pray privately, that is more than permissible as long as it is not being led or sponsored by the public school. All right, another case involving the freedom of religion deals with Wisconsin v. YODER in 1972. And this is going to rule that the government cannot force Amish students to attend school past the 8th grade. And in this case, it's going to take the free exercise clause in stating that religious freedom outweighs the state's interest, in this case, in educating children. And they said by trying to force these Amish students to attend, 8th, 9th, 10th grade, that this was a violation of the free exercise clause in the First Amendment. So in this case, a religion has to be established, has to be an ingrained practice for this to occur. But once again, notice that the Bill of Rights are being balanced between the power of the government and the civil liberties of the citizens. Okay, dealing with student rights in 1969, Tinker v. Des Moines. And this is where public school students are going to be protesting the Vietnam War by wearing black armbands in, again, protesting the Vietnam War. And they are restricted from doing so. The students actually fight back, And the Supreme Court rules on the side of the students, saying that wearing such armbands is a form of symbolic speech that's protected by the First Amendment, and that not all rights are lost once the students come into the school. So this is a big win for the students, and it's going to establish what's known as the Tinker Test. And it's basically going to say more or less that if what they're wearing is a distraction to the sole mission of schools, which is to educate, then it can be restricted. If not, it cannot be. And again, students have been wearing political shirts, prior to this, and the fact that they're wearing an armband with a peace symbol in and of itself is not going to distract from education. Once again, notice here what the College Board wants to emphasize here, that the Bill of Rights are being balanced between the power of the government and the civil liberties of students, in this case, dealing with the students. Okay, so fast forward to continuing on to 1971, in a case, a very landmark case here, the New York Times versus the United States. And this is going to increase the freedom of the press quite dramatically by making prior restraint more difficult, even in cases that deal with national security. When we talk about prior restraint, we're talking about censorship. That is very, very difficult for the government to be allowed to censor any newspaper, even if it could deal with national security. So again, big win for the freedom of press. It's very, very difficult to censor the press. And again, notice that the Bill of Rights are being balanced between the power of the government and the civil liberties of citizens. All right, going to 1919 in a case known as SCHENCK v. U.S. This deals with the draft in World War I. People were giving out pamphlets encouraging people to avoid the draft. And the Supreme Court is going to rule in saying that, well, in this case, that speech that causes a clear and present danger is not permitted under the First Amendment. And this is going to restrict people's rights. Now, that law saying that you cannot give out those pamphlets is eventually going to be overturned many decades later. But the clear and present danger test is going to remain. Here's sort of the classic example. You walk into a movie theater and you start yelling fire. That certainly is going to create a danger, as people are going to be rushing for the exits. They could be, stomping upon one another, and it could cause a lot of chaos. So the clear and present danger test is still used today as well. And again, notice that the Bill of Rights are being balanced between the power of government and the civil liberties of citizens. Okay, let's go to 1963 in a case known as GIDEON v. WAINWRIGHT, dealing with the Sixth Amendment. And this is going to guarantee the right to a public defender for criminal cases. And it's no longer just having the right to a lawyer. Now it's going to be a lawyer given to you by the government in the event that you cannot afford one. Notice here that the Due Process Clause of the 14th Amendment has protected individuals from the state infringing upon one's liberties. In this case, the right to a lawyer. So this is going to be a big win for criminal defendants who cannot protect themselves in court. And again, this only pertains to criminal cases. In the case of Roe v. Wade in 1973, this is going to be using the Fourth Amendment. Typically, the Fourth Amendment is seen as the privacy amendment, and people tend to think of the Fourth Amendment as ones that deal with search warrants and the right to be secure within your own house. However, in this case, the Fourth Amendment is going to allow for a woman's decision to have an abortion. Certainly, this is probably one of the most controversial cases, but this is going to be ruled on the grounds of privacy. Once again, notice that the Due Process Clause here of the 14th Amendment has protected individuals from the state infringing upon one's liberty, and that one dealing with your right to privacy. But again, very, very contentious with respect to that particular Supreme Court case. Okay, and then a case involving the First Amendment in 1925 is GITLOW v. New York. And why this is important is it establishes a very important concept known as selective incorporation, where it's ultimately going to be ruled in a case known as Barron v. Baltimore that the Bill of Rights does not pertain to the states, that it was included only to pertain to the national government. If you recall, during the time of ratification, that the states wanted extra protections from the national government, and that's why the Bill of Rights came about. So what's going to happen is that the courts are going to rule that through selective incorporation, each aspect of all 10 amendments is going to have to carefully be incorporated. And when it's incorporated, that now means that that particular aspect of that amendment is now going to pertain to all 50 states. But it's going to have to be done by amendment. In some cases, as you see in GITLOW v. New York, only specific aspects of that amendment are going to be incorporated to include all 50 states. The idea was that originally that states would have these protections in the first place. However, not all states are going to have that. So why GITLOW v. New York is important is it's the first case of selective incorporation, very important to know that concept, and it's going to establish the First Amendment protection to citizens in all 50 states. And it's going to say that states can prohibit speech that causes a danger to public safety, but if it doesn't, then they cannot restrict that. And again, notice, as I've been including on these slides here, and this comes straight from the College Board website, that the Due Process Clause of the 14th Amendment has protected individuals from the state infringing upon one's liberties. That is very important to know. And the last case we're going to deal with until we go to part 2 is dealing with the Second Amendment. This is much more of a recent case in McDonald v. Chicago, and it's going to use selective incorporation to now extend to the Second Amendment, the right to keep and bear arms. And this is certainly one of the more contentious amendments in the news. And in this case, you have a lot of restrictions on, almost impossible to get a gun. And ultimately, this is going to go to the Supreme Court, and it's going to be ruled that no, you still have a Second Amendment right to carry a weapon. Of course, that can be restricted depending on which state that you are on, or live in, rather, whether that might be that you have a mental illness or a criminal record. But for the most part, it's going to say if you don't have either one of those, that a state cannot prevent you from owning a weapon, in this case, a gun. So again, notice the Due Process Clause of the 14th Amendment has protected individuals from the state infringing upon one's liberty. So that's going to deal with the first half, segue into part 2 for the remaining cases that you need to know for the AP Gov exam.